group of general education teachers trained to deal with English learners? Did the student actually get the services that they needed? Did they get the support that they needed? And keep in mind that proficient and fluent are two totally different things. To be proficient to move on to other gen ed classes is one thing, but to be fluent means you don't really even have to think about it. It just flows right out of your pen or right out of your mouth. And most of our English learners, when they exit, are not fluent, they're proficient. So that's why we've heard the verbiage change from fluency to proficiency more and more over the years. What are all the We to Cut scores from 2015 to 2018? Those are actually posted, and you can go back and look on the Tennessee website. If you have trouble finding those, you can. And I think Adam talked with you this morning about how we set those cut scores. We will probably be taking new scores to stakeholders and to State Board to consider, do we need to up those exit scores this year? Some of the information that Adam showed you indicates that that might be a good thing for us to do. So we are considering that, and we will certainly do that if we think that it needs to be done. Again, if you have input, please share that input with us. Since we wait to put high school students into English at the 3.5, wouldn't it make sense to also wait for math? Putting a newcomer into algebra is an ongoing problem for many ELs. They could take more math later after they've gotten more proficient. Right now, we are told that they have to take a math class every year, and we don't have the right to change that. If you feel strongly about it, reach out, let us know, and we will present that to the people who need to hear that presentation. And some of you have been very good about that. You've talked about you need a math class that kind of goes between general math and before Algebra 1, that some of your students are not ready for that math. We'll try to help you as best we can, but they don't come to me or to Katie or to Joanne and ask us how state laws need to be changed. So we don't change those. We just try to give you the insights you need. ESL students with disabilities or special education students, allow students with text-to-speech on IEP to have them the same on access. Yeah, we've talked about that quite a bit. Not all of your students need blanket coverage. If that's not an accommodation they are using in the classroom and that they don't need, giving it to them on assessment day is usually an issue. It's usually not the best thing. But if it's an accommodation that you use in the classroom and you use for many of your assessments, and you see that it's beneficial to the student, they certainly should have text-to-speech. And that is allowed. There is a process that your district testing coordinator may have to help you with, getting that into the Nextera platform, because you can't do it the day of the test. You have to have this pre-planned, and it has to be set up much in advance. So I would encourage you to start conversations now about the accommodations you need. The individual learning plan is a great place to have that information. So please put it there, and then teachers can discuss it. Once it's written down, you may find general education teachers saying, I don't think that's a good accommodation. It doesn't help them in my room. We need something different. We lost your mic, Katie. No, there it is. All right. All right. Why isn't grade level taken into account on the growth standards? We have some real issues with differentiating by grade level, because the law basically says we have to exit on the same criteria. So if we score differently for high school than for first through third grade, we have to justify that, and we have to show statistically that it's equitable. And that's not an easy path to take. Doesn't mean we can't do it or won't do it. Thank you. It doesn't mean that we can't do it or won't do it, but it's something we're considering and we're looking at. But it's true that our newcomers grow fast. They grow very fast. And maybe that growth slows down. Some of you remember that old that triangle, the V, where at the bottom there's not much breadth to level 1. So there's a little more depth, but they grow very fast out of level 1 into level 2. But by the time they're in level 3, it's very wide. There's a lot of breadth and depth there. And so they're not going to grow as quickly, and we know that, and we have to compensate for that. Okay. Criteria for determining difference between ESL's direct service curriculum versus RTI intervention program and curriculum. And I'd make Joanne answer this, but she's hoarse today, so we're not going to make her suffer. They want to know the difference between direct service curriculum for ESL and RTI. And RTI and ESL can work together and need to be coordinated. But there's a difference. ESL is about broad-based communication. If we have a student and they say something or write something that's communicative, and maybe the verb tense is wrong, the spelling's wrong, the punctuation's wrong, but it's communicative, and they're beginner, low, intermediate, we're very happy as ESL teachers, right? They're communicating. But much of RTI is very discrete point. And so there's a time and place for RTI and ESL to merge, and there are other areas where we have to use it a little more skeptically. To expect a beginner in ESL to get certain very discrete points and very discrete skills that are sometimes contained in RTI is not good. But we need to coordinate those services. We can't just say, okay, they're beginners so they don't get RTI, or they're advanced so they get RTI and don't need ESL. What we need to do is look at each student individually and see what they need, and that's what should be in that ILP, what they need and how we're going to deliver that. You want to come talk? Or you're good? Okay. All right. And again, when you have questions, reach out to us. We answer a lot of questions and provide quite a bit of assistance during the weeks. Okay. Why are WIDA and member states forcing children to take speaking tests with headphones on their ears, microphone near their mouths, hands on mice, any audio in their ears, clicking on mechanisms, turn it off? There's been a lot of controversy about computerized testing, but this is the way assessment's going. And so our suggestion is that you start working with these kids right now, if not last week or last month, on how to use those devices. Don't let the first time they've seen that headset be the day you give the test. Be sure that you're letting them practice with those pieces of equipment and get used to it. It is not intuitive to wake up in the morning and go sit down and talk to a plastic box. I never get my coffee and go talk to my computer alone with a headset on. It's not intuitive for these children to do that. So first you have to establish the rapport and teach them how to use the features of the mouse and the features of the assessment. There are practice assessments on all the summative assessments that are given. Please use that information to train your students. And somebody says it's terrifying and completely abnormal way to speak. That's not what caused the drop in speaking scores, though I'm sure it contributed to it, all right? However, it is not intuitive to do it that way, and we do need to work with the students. What I've noticed sometimes is that it's not only the children that are a little nervous, the teachers are a little nervous that the equipment's going to malfunction. So please be very confident with your equipment. Let them practice with it so that they feel some confidence. I'm going to let Katie talk for a while.
Thanks. So I have a few more questions here. One question is asking about more information regarding using growth trajectories in ILPs and what growth expectations should be. As a part of some of the resources we used during the summer ILP training for teachers, there is a tool that was developed that uses the growth trajectory built from the accountability protocol. So if you'll look in the accountability protocol for 2018, it's the same chart that Evan showed earlier. It shows that expected 1-year growth and the 2-year growth. And so we have a tool that is available to be able to auto-populate that when you enter in student data. And so that's one way to build the tool in and of itself. And what we like to think about the growth trajectory is being as looking at where your target is and then using the ILP to build out all the ways you're going to get to that target at the end of the year. And the growth trajectory itself can be in the ILP. It can be a separate document that just accompanies the ILP. It's not prescribed as how it's supposed to work, but we like to think about it as looking at some of those growth standards and thinking about where's the student now and then how do we get them there using all of the can-do descriptors and any other information that you might have in the ILP. And so that's how the two work together. So the data from the ILP would go into the growth trajectory. The growth trajectory would set a broader goal for the end of the year, and then the ILP would fill in all of those steps to get to that goal. And then when you reach that goal, you have all new data to populate an ILP again, and it's kind of a cycle. All right. Can you talk about strategies for developing or monitoring ILPs for waiver students? So as we mentioned, students who have waived direct services are required to have an ILP, and it would be the general education teacher's responsibility to do this ILP, but that doesn't mean that the general education teacher has to be completely alone in working on the ILP. What we would really strongly recommend is if you have teachers in your school that are working on ILPs, ESL teachers, to allow that general education teacher to have that time to collaborate with them and learn with them and do more intensive professional development with them so that they're not left entirely isolated to work on the ILP by themselves. Is there a chart for expected 2-year growth for access? So the best description I can think of for that would be looking at the accountability protocol, the 1-year growth standard, and then the 2-year growth standard information. And that, again, is in that same table that Evan showed us from the accountability protocol earlier. You'll notice there are 2 columns. There's met the growth standard in 1 year and then met the growth standard in 2 years, and referring to the 2nd year column for that information. And where is the long-term EL guide? The long-term EL guide is available on the TDOE website. What's most helpful is actually just searching English learners on the little search bar on the TDOE website, because I myself have not figured out how to navigate to the English learner webpage. So I just bookmark that. And there's a long list of resources on there, and it should be in that list. It's also going to be available in the TDOE resources section under English learners on the ePlan website as well. And finally, is there any specific data for districts on what happens to our English learners after graduation? So there is that data, but because it then kind of moves out of the Department of Education's hands, which is K through 12, over to the Tennessee Higher Education Commission, that data does exist to a degree. There's not always like really awesome connections made between that broader longitudinal system. But analysis of that information would fall under THEC, or the Tennessee Higher Education Commission's kind of purview and umbrella. So there is some information there, and if you're interested, reaching out and continuing to tell us that you're interested in that, we can always continue those research conversations about looking further. With the information that we have, probably looking at ready graduate information would be the best thing with the data that we have under our umbrella at the TDOE, which again is just K through 12, so post-graduation would fall under THEC.
Okay, thank you, Katie. We're not going to stop at this point for questions. If you have follow-up questions to the questions we tried to answer, feel free to put it on the parking lot or save them. We'll have some time at the end of the day for some questions where you can use the microphone also. Right now, I would like to introduce our next speaker. Oh, yeah. If you have not signed in, we need you to, because we have to justify this to the department that this is a worthwhile day. So if you have not signed in, please see us, and we will get the sign in to you. Katie and I are here at the front table, and so go for it. Yeah, or if there's some out there, they can use. Okay. Okay.
Because we're going to change over to.
Okay.
Sorry.
All right.
Do you want to pull up my slides?
Yeah.
Oh, you can do it. Okay.
All right. Don't get noisy. You'll miss one of the very best parts of the day.
I don't think so.
We have our.
This is on. Oh gosh.
If you could move your conversations out into the hallway where I can introduce our speaker, that would be helpful. All right, thank you. Rachel Supay is the OCR attorney on our floor, and Katie and I are very lucky.
So I shouldn't mess up. Okay. Okay. All right. So you can all hear me okay? Hi. This is a large crowd. Thank you so much for having me here today. I see a lot of familiar faces in the room, but it's really great to be here and to meet all of you. As Jan said, I am our Assistant General Counsel for Civil Rights and Special Education. So I work with districts on training and technical assistance for Title VI, Title IX, IDEA, and Section 504. And I also conduct civil rights investigations for students or staff or really anyone who would like to file a civil rights complaint against their district. So today what I'm going to do with you is give you a really broad overview of the civil rights protections that are available to English learners and their families. Again, this is broad, so I'm not going to get too into the weeds about the specifics of programmatic issues. I know you've already heard a ton about that today. So please do stop me at any time if you have questions or comments or want to share with me how something works in your school or in your district. And you know, my goal is not to lecture you for an hour and a half. So I invite you to participate, chat with your neighbor, if I stop for certain discussion points, and just be as engaged as you would like to be. So let's go ahead and get started. Here's what we're going to cover today. We will review civil rights laws obligations for English learners. Now, for many of you, I know you already know this information. It's going to be a bit of a review, but I'm told there's kind of a mixed bunch in the room, so this might be new and helpful for some of you, I hope. Oops. Then I'm going to give you the top 10 legal requirements under Title VI. These top 10 items have been put out by the U.S. Department of Education, Office for Civil Rights, in a 2015 Dear Colleague letter. You'll get copies of these slides, and in the end of the presentation, there's a ton of hyperlinks with all the resources that I'm referencing today, including that Dear Colleague letter. Then I want to also cover bullying and harassment of our English learners and immigrant students. That is covered by Title VI as well as the Tennessee state bullying law, and I think it's an important discussion that we have. And then finally, hopefully I've saved plenty of time for Q&A. It's always a little bit hard to plan out how many slides, but like I said, don't feel like you have to wait till the end. If something's not making sense, just go ahead and raise your hand and we will stop. So let's dive into it. I'm not so great with technology. Come on, there we go. There we go, okay. So, Title VI of the Civil Rights Act of 1964, I'm sure you've all heard of that. It prohibits discrimination on the basis of race, color, and national origin in all programs and activities that receive federal financial assistance from the U.S. Department of Education. So of course this means all public schools. I want to make sure we are all on the same page about what these different terms mean that I'm about to use. When I refer to discrimination, it refers to conduct that deprives a student of the benefit of an educational opportunity on the basis of their race, color, national origin, sex, or disability. And harassment is considered a type of discrimination. That is behavior directed at students based on the protected characteristic and that interferes with their academic performance or their participation in the school's programs or activities and creates a learning environment that a reasonable person would find threatening, intimidating, or hostile. And then lastly is retaliation. That is an adverse action taken against an individual for filing a complaint or participating in an investigation. So let's say you are a student and you feel that your ILP hasn't been followed, and you file a complaint with me at my office, and then all of a sudden all your teachers start giving you an F. That's retaliation, right? Or let's say as part of that investigation, I come down to your school, and interview a bunch of staff to get their take on what happened. And the next day, you're terminated for being so candid with me. That, again, would be retaliation. So everyone is protected against retaliation. So there's two types of discrimination that I want you to be aware of. The first type is disparate treatment. That is when a school or district intentionally treats some students worse or less favorably than other students because of their protected class. So this is when a school or a district, they're kind of expressively or expressly, I suppose, discriminating. They're not trying to be covert about it at all. They are just coming out with it. So can anyone think of an example of what that might look like? Anyone want to raise their hand and take a guess? Yeah, go ahead. Yeah. Great. So the example that she gave was if a school had a policy of automatically placing all students who were not proficient in English in first grade when they really should be in fifth grade, something like that. So it's these categorical policies or exclusions. So here's the example that I like to use. Let's say a school had a policy that Spanish-speaking students may not join the drama club, right? That's not hidden discrimination. They're just coming out with it, right? It's pretty obvious. Now compare that to what we call disparate impact. And this is just as important to know, if not more so. So this is when a school or a district does not intend to treat a certain class of students differently or worse, but their actions have kind of the unintended consequence of doing so. Their actions have the effect of treating some students differently. So in this situation, when we're talking about disparate impact, the focus is not on the school or the district's intent, whether they wanted to discriminate or not, but whether there were discriminatory consequences. This one's a little trickier to identify, but can anyone take a guess? Anyone want to be bold this afternoon and try and think of an example of what this might look like? I'll let you think about it for a sec. Any takers? This is a hard one. Yes, go ahead.
Maybe pulling students from recess for ESL classes.
Bullying students during recess for ESL classes?
Yes, so they're not able to have recess.
They what?
They're not able to have recess.
Oh, okay. Yeah, that could be an example. I would want to know more about, whether the teachers were monitoring the recess or what kind of policies or procedures were in place to combat that situation. Here's the example I like to give as a comparison to the first one. Students without US birth certificates may not join the drama club. So compare that to the first example in the third bullet point. In the first example, they're expressly talking about Spanish-speaking students. In the second example, they're not naming any protected classes, right? But we know what's going to happen and who's going to be affected by this policy, right? Especially if it's in, let's say, a district with a large Spanish-speaking population. The consequence of that policy is going to have a discriminatory effect on English learners and immigrant students. Does that make sense, the difference? Any questions so far? I know this is, oh, go ahead. Great question. That's a great question. So the question was, does it have to be a formal written policy? No, and I'm glad you brought this up. If a school is using any kind of practice, protocol, flow chart, decision-making structure that has these effects, whether or not they're written down, it would still be prohibited. And again, it's not often intentional when we're talking about disparate impact. So sometimes school or districts might not even realize. But if you, think that you might have a problem at your school with something like this, I'm happy to talk through that in more detail with you. Any other questions?
Kind of back to the recess question. If it's a scheduling issue, and that's the only time that they can be pulled from recess or their special area classes to take ESL class.
Mm-hmm. So are you asking if, if there was a situation where all the students at the school got recess except for English learners?
Because that was the only time during the schedule that they could have ESL.
That's a good question, and we're going to talk in more detail about what the scope of this is, but Title VI does apply to all programs and activities of the school. So you want your students to have equal access. You want your English learners to have equal access to the same opportunities that non-English learners do. And sometimes that means getting a little creative with your scheduling. So sometimes as a team, we try, if we hear from districts that they're having scheduling concerns or struggles, we will try and come up with some solutions to help deal with that. Any other questions? All right, I will keep moving forward then. Oh, I'm glad you brought this up. It brings me to my next slide. Title VI and really all the civil rights laws are incredibly broad. So they don't just apply in the classroom. They apply to academics, extracurriculars, or athletics, you name it, pre-K programs. They apply if you're on a field trip. They apply to any school-sponsored activity. And when I say even those that occur off campus, again, if it's a school-sponsored field trip, a spelling bee that's taking place in the next state over, or even, well, those are good examples. Those are my two examples, but you understand that the policy follows you to any school-sponsored activity. So I will quickly run through some important Supreme Court cases. This is pretty dry legal nerd stuff, so bear with me. But the first case we're going to talk about is a case that you've probably all heard about. It's called Lau versus Nichols. And in this case, the Supreme Court said that in order to comply with Title VI, districts must take affirmative steps to ensure that students with limited English proficiency can meaningfully participate in their educational programs and services. And I want to read you a great quote from the opinion. The court said, "There is no equality of treatment merely by providing students with the same facilities, textbooks, teachers, and curriculum. For students who do not understand English are effectively foreclosed from any meaningful education." What does that mean to you? What do you think that refers to? Or how does that apply to us in our schools in Tennessee? Equitable, right? Handing someone a textbook and a teacher is not necessarily providing access, right? Good. Any other thoughts on that you want to share?
That's the basis for modification.
Exactly. This is why some students need modifications or accommodations. We want to make sure that everyone can participate or access the program in an equitable manner. Yes, in the back.
It seems like the original ruling applied to the language of instruction, but here in Tennessee we're English only, so when it comes to content instruction, it becomes a very big problem.
Yes. Well, I have a slide coming up in a little bit about the English-only law. It's hard because there has not been any Supreme Court case that has explicitly said no English-only laws are allowed. So the court has never said that that's prohibited. But what it means is that in states that do have English-only requirements, we have to essentially be a little more creative and try and make the most of a situation where staff working with English learners have to communicate and instruct in English using some other techniques. I know that's not an ideal answer, but we'll cover it in a little bit in more detail. Any other questions? You guys are a chatty bunch. I'm really glad. Go ahead.
How can you get a meaningful education when you can only provide education in English and they don't speak?
Did everyone hear that? How do you provide a meaningful education when staff are only allowed to instruct in English? Now, the English-only law has been on the books for many, many years. And I'm trying to think of the best way to answer it, but this is the reality that we are currently operating in, and I know that it can make ESL instruction difficult. I acknowledge that. And I will let Jan or Katie, if anyone else has thoughts on that, want to throw me a life vest here. Right, so you can use the student's language. So it's not that you're not allowed to speak other languages, right? It's just that the instruction and the teaching itself is to be done in English. Do you want to add anything?
Well, we don't have a certification for bilingual ed. So we would have no way of certifying that teachers were actually qualified and fluent in languages if we had bilingual programs. So that's a step that would have to be put in place first. We also have about 70 to 80% of our kids are American born and don't really have a firm foundation in that first language. So is it better to try to teach them in Spanish when English may be more dominant, or is it better to try to teach them, ideally we would want to teach them in both languages, but we don't have that situation in place at this time.
Just one other angle on this. So I have a son who speaks Ukrainian, and I think it would fall under discrimination if there was a language other than English used in the classroom. That would be discrimination against him. So I think it's kind of tricky.
So you mean, let's say, usually when we think of ESL, sometimes the first thing that comes to mind is Spanish, right? But if you're saying that if your child who speaks Ukrainian was in a room where the teacher was speaking Spanish, what help would that be for your son?
It's not equal access.
Right. Any other thoughts before oh, okay, go ahead.
I was going to add that to answer your question there, that content teachers need to make the instruction comprehensible for the students that are in their class in English, and it is possible. That's where we need more for our content teachers, for them to be providing instruction that is comprehensible.
Great. Thank you all for sharing. Those are all very helpful, and Jan put it much better than I did. So let's keep going with some other cases. Oh, one more.
Sorry, this is related to parents. On Cloud versus Nichols, a big question that I think comes up is for students to be able to participate in activities, So we know that if a student is going to participate in something, we have to make sure like if there's a form or something the parents can access that so they can know what they're signing and then child can be a part of it. But what if in place, somehow in place, we have a situation where it falls back on parents for them to have it translated and possibly pay money for?
That's a great question.
And are parents included in that?
So I have about 4 to 5 slides coming up. I'm glad you guys are thinking ahead, because that shows me that you should all be attorneys for the state with me. But we are definitely going to spend a lot of time talking about communicating with limited English proficient parents, because they do have rights too. We'll cover that. All right, the next case from the Supreme Court that you've probably heard of is Castañeda versus Picard, which is a 3-part test that the courts will use to evaluate your ESL program that you use in your district. The court's going to ask 3 questions. Is your program based on sound educational theory as judged by experts in the field? So if your program in your school is to plop kids down in front of YouTube and tell them to look up some videos about English, that's not going to cut it. I know that's probably a very extreme example, but you get my point. Are resources and personnel calculated effectively? And again, we'll talk more about these in detail. And is there evaluation and adjustment made from the evaluation? If you notice there's a problem with your program, are you taking steps to improve it? Another important Supreme Court case is Plyler versus Doe. And this is a case that said school districts may not deny public education to children on the basis of their immigration status. This is obviously a really hot topic right now, and we are going to cover it in much more detail at the end of the presentation. Some other statutory laws that you should be aware of, I'm not going to go into too much detail because we got to get moving, is the Equal Education Opportunity Act of 1974, which essentially Congress took the ruling from the Supreme Court in Lau and codified it into statute. And essentially that does more to make it more permanent than a Supreme Court case does, which could really be overturned easier than a statute. And then you're all familiar with Title III, which essentially provides subgrants to school districts to help support the ESL program. All right, here is the legal definition of English learner. I mean, you can sure count on our legislators to write wordy laws, right? This is kind of a mouthful. I will just let you look at that for a minute so that you probably don't want me to read it all to you, but the important things to know are that it's an individual who is 3 through 21, enrolled or preparing to enroll in elementary school or secondary school, and then 2 of those last bullet points as well. So either they weren't born in the United States or their native language. I guess I am just going to read you the whole thing. Their native language is a language other than English. They are Native American or Alaskan Native or a native resident of the outlying areas and who come from an environment where a language other than English has had a significant impact on the individual's level of English language proficiency, or who is migratory, whose native language is a language other than English, and who comes from an environment where a language other than English is dominant. I need a break. That's quite wordy. And the other criteria is that they have difficulty speaking, reading, writing, or understanding the English language, such to that it's essentially interfering with their ability to become proficient in accordance with state assessments, or in any way hindering them in school or society. Those are the Cliff Note versions. All right, so let's dive into it. Here are the top 10 legal requirements that we are going to cover. Districts must identify and assess all potential English learners, provide English learners with a language assistance program, staff and support the ESL program, provide meaningful access to curricular and extracurricular programs, avoid unnecessary segregation of English learners, evaluate English learners for special education or 504 related services, and ensure FAPE, a free appropriate public education, if that is needed for that student, meet the needs of English learners who opt out, monitor and exit ELs from the ESL program, evaluate the effectiveness of your program, and then last but not least, communicating with limited English proficient parents. So let's just go through these in chronological order. The first requirement, which I'm sure you're all familiar with, is the process of identifying your English learners. I like to think of this like the ESL version of Child Find, right? Are there students who live within your district who you have a legal obligation to identify and serve? So this is a 2 to 3 step process. Number 1, we give out a home language survey to new families that are enrolling in our district for the first time. If there's any discrepancies or confusion about the answers provided on the home language survey, you are encouraged to have a conversation with the family to try and get a better sense of what their home language is. And then the third step is the screener, either with the WAPT or with the WITA screener. And that's going to help you narrow down that pile of students who answered a certain way on the home language survey down to the ones who are actually qualified for services. This is written in our state board policy 3.207, I believe it is. These are the 3 questions that the home language survey must ask. What is the first language that the child learned to speak? What language does this child speak most often outside of school? And what language do people usually speak in the child's home? I want to note one thing, because this tends to come up a lot, but a student, or a family rather, should really only be filling out a home language survey once in their academic career. So, I know. Don't shoot the messenger. I know this is not what's actually happening in practice all the time, but this is what the policy requires. So this is, sometimes we hear about schools that are giving them out on an annual basis. That's not something that needs to happen or should happen. That first home language survey that is turned in is the legally binding one. And if you have a student who transfers from school to school within your district, that should be following that student in their cumulative folder. What? Do you want to say that a little louder? Outside the district. Ideally, it should follow them outside the district too, but I know that things can get lost in the shuffle much easier when that happens. Never mind if they're moving out of state or coming in from another state. So sometimes if let's say a child moves here and we have no data about their past history and past whether they are an EL at their old school, whether they've even been to school before. So sometimes there are of course exceptions. This is a very generalized, broad rule. So there are exceptions when a child might have to, or a family might have to fill one out another time. I'm seeing a lot of hands up, so should I be nervous? Go ahead.
What happens with a family who, they're here illegally, so when they filled out the form originally, they put English, because they were afraid of being identified. Then they come the next year, when they feel like it's a friendlier environment, and they want to change that. What do you do?
That's a good question. So if a student or if a family intentionally fills out their home language survey incorrectly. So the policy says, let me bring up my next bullet point. Oh, there it is. So the policy says if the answer to any of the questions is a language other than English, move forward with the screener. But if it says English, 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 it's not our place to second guess that. If you think it was an error, you can have that conversation and just make sure, but if a family says, no, this is correct, there's no exception. We can't be in the business of making exceptions to the policy that aren't written into the policy.
So the parent comes to you and says, I purposely did this, I was afraid.
Okay.
At that point, what do we do? This is new for me, so I wasn't sure what to do about that.
Yeah, I will let my friends at this table answer as well, but my understanding is that that is a local level decision. If it appears to be an error, that's up to the district. Is that right, Jan?
You need to have a procedure in place for handling that sort of thing.
Mm-hmm.
All of this needs to be in a procedure that you follow every time so that you're equitable with the students.
Yeah, so
But there is a way to correct a mistake. It's just that it needs to be not we do it this way for this student and that way for another student.
that's right. The important point is that it has to be consistent. So if ever any family comes to you and says, I made a mistake on my home language survey, whether the parent is proficient in English or not, we want to treat all of the students the same way. Did you have a question?
I do have a question about preschool.
Preschool.
Does that count as first enrollment in a U.S. school if it's a preschool that's at an elementary school?
So are you saying, do preschoolers fill out a home language survey? My understanding is no, that this only applies to elementary and secondary school.
But if they do,
So if you gave it to them, that's a good question. I've never had that question before. What do you think? If it was accidentally given to a pre-K family?
I think they need a procedure. You need to say that you either count
Yeah, going forward, I would not give them out at that level since it's required for elementary, but if it's been done in the past, you can probably use it, but change the procedure going forward. Yes? Yeah. So the proposal was to be able to upload home language surveys to EIS. Now, I'm not a tech person, so I don't know the feasibility, but I know that EIS should list a student's categorical status, whether they're an English learner or a former English learner, transitional. Is that all listed in EIS?
I don't think we can upload home language surveys to EIS. It may be when there's a new data system we can.
Yes.
You could upload them to other places, but you'd have to redact their name and social security numbers. No, IOPs are not uploaded into EIS.
We can talk about that on the break in more detail. We can certainly check what the policy says. I'm going to keep moving forward. I'm glad you all have good questions, but I don't want to run out of time. So now let's move on to the screener. Remember that students have to be screened in all 4 domains. I've given an example. What if you were to assess students in only listening and speaking, but not the other 2 domains? You could potentially have a huge underclassification of English learners, right? In kindergarten as well? No. There is an exception for kindergarten. All right. All the details of this and what the screener scores should tell you are located in state board policy. So this is something that does come up in the schools or districts sometimes. Remember that a determination about whether a child qualifies for ESL should only be made using this process. So a teacher's opinion, a parent's opinion about whether or not a child is proficient really can never, ever substitute for a standardized testing process. And that's because what one teacher considers to be proficient, another teacher might not, and it's just too subjective. The law says that school districts must provide parents with notices within 30 days to the parents of English learners regarding their child's identification and the services that they are offered. So I know 30 days comes up real quick, but that is what the law requires. You are to identify your English learners within the first 30 days. We have this helpful flow chart. I know you can't read it, it's too tiny, but I think it's very helpful. It's listed in our ESL manual, and it does walk you through step by step what that process needs to look like. So let's move on to number 2. So now you've identified your group of English learners, and you must immediately provide them with appropriate language-assisted services. We talked about how these services must be educationally sound, but the civil rights laws do not require any particular program or method of instruction. But here I've listed for you the allowable service delivery models that are listed in state board policy for our schools. We've already talked a lot about ILPs, so I'm not going to really get into it in too much detail. I know that Katie and Jan and Joanne have already spoken to you a great deal about that. Staff and support the ESL program. So districts, of course, have an obligation to provide sufficient personnel and resources necessary to effectively, that's the keyword, effectively implement their program. This includes having highly qualified teachers to provide the services, trained administrators who know how to evaluate those teachers, and adequate and appropriate materials for the programs. And again, that language comes from federal guidance. So here's a quick reference to the state board policy regarding class size and the teacher-to-student ratio. 35 identified ELs per full-time ESL teacher, unless approved otherwise by TDOE. And ESL teachers in Tennessee must hold an ESL endorsement. Any questions so far? Yes, in the back.
What do we do when our county tells us to serve students, make them our priority? We have to forego lunch and planning in order to meet the requirements because we're so far spread out, we're traveling to 3 schools in a day. There's no way we can serve these kids adequately, get a lunch or a planning.
Did everyone hear the question? Okay. So, all right, let's come back together. It was a good question. So it's kind of a two-part question. I mean, if you feel like your district isn't allowing you to properly serve students and it's having a harmful impact on the students, you can file a civil rights complaint. That is risky, of course, for teachers to do. But that is one option. You know, from an employment perspective, if you're not having planning periods or lunch, that would be something you would take up with your director of schools from an employment HR perspective. Yes? Right. I know. It is the law that you do have to have those times. So if your district is not allowing you to, that would be concerning. And I can talk to you afterwards about what your legal options would be. All right, I'm going to keep moving forward. Just a note, again, this comes from federal guidelines. Paraprofessionals, aides, and tutors may not take the place of qualified teachers, but they can be used as interim temporary measures if your school or district is in the process of bringing on qualified teachers. But again, if you do use paraprofessionals or other kinds of aides, they should be supervised by a qualified teacher. A teacher who is qualified to teach ESL, sorry. And again, this is in state board policy, but all teachers working with English learners must be trained on WIDA English language development standards. I'm going to skip through some slides that have kind of more programmatic items because I want to make sure we have time to talk about the more civil rights focused. So Jan's already touched a little bit on retention. Here's just a very high-level summary. English learners have to be placed with age-appropriate peers. English learners may not be retained solely due to their language ability. Solely being the key word. That can't be the reason for retention, okay? I've already talked about the scope of Title VI and how broad it is and that it really does apply across the board to any school or district-sponsored activities. Okay, avoid unnecessary segregation of ELs. Title VI says that ESL programs may not unjustifiably segregate students on the basis of national origin or English learner status. Unjustifiably, again, is the key word there. Doesn't mean they must never do it. So sometimes in ESL programs, a student might be pulled out of the classroom for certain periods of time, and that's okay. That doesn't violate Title VI. But essentially, it has to be done in the least, kind of like the least restrictive environment when we're talking about children with disabilities, right? We want to keep it to a minimum. This is something that's highly scrutinized by OCR. I'm sure some of you in this room have been on the receiving end of an OCR investigation. I have myself, and it is not fun, right? It's a very lengthy, difficult process. So do keep in mind that this is something they look at to see if, are your English learners being segregated from other students during art class, during recess, lunch, in settings where there's really no educational reason for them to be segregated. And And of course, some English learners may have a disability, or you might suspect that they have a disability. So just like any other students, you would want to evaluate them for either special education or 504 related services. It is a little trickier sometimes if a student doesn't speak a great deal of English. So here are some pointers from DOE on how to do that. They do recommend that you keep in mind when you're doing any kind of special education or 504 evaluation, you want to consider the student's level of English proficiency and make sure you're factoring that in to any assessments and evaluation resources and materials that you're going to use. Now, I know this sounds silly, but it does happen. School districts must not identify or determine that English learners are students with disabilities because of their limited English proficiency. Meaning, just because a child is not proficient in English does not mean that child has a disability, right? I know that sounds obvious to everyone in this room, but sometimes we do hear about English learners being placed in maybe special ed just because they are not proficient in English, and that is absolutely not the correct placement for them. At the same time, though, districts cannot prohibit dual services. So if you have a student who is both an English learner and needs special education or related services, you never want to tell a parent to pick one or the other, because if a child needs both, they're entitled to both. We doing okay? Okay. I didn't write these laws. I'm just telling you how to follow them. All right. Next, we want to meet the needs of English learners who opt out. So of course, as we all know, parents do have the right to decline some or all direct ESL services. However, again, highly scrutinized by OCR, a parent's decision to opt out must be knowing and voluntary. So OCR will really, they do crack down on this, and that makes sense. We want to make sure that a parent has every resource and piece of information they need to make an informed decision. So if you're just handing a parent a waiver in a language that they don't understand, that's not informed decision making, right? So OCR will examine your district records, including any documentation of the parent's opt-out decision and whether the parent signed the documentation. So I will always recommend that you have documentation, thorough documentation about a parent's decision to opt out. Yes, in the back.
Sorry, I'm going to go back to the last bullet that you have. I've run into a situation where I have two ESL students that I recognize to have some serious special ed issues.
Uh-huh.
One of them was tested and denied special ed services because they speak Spanish at home. Therefore, they couldn't rule out that his issues were ESL. So he is being, this blanket is not going to qualify right now. I have another child that doesn't speak English. This is going on third year in America, still can't learn, has an issue, has a problem. But because they don't speak English, they can't be tested.
So is the district refusing to evaluate them?
They're saying, what do we do? They can't speak English.
So there's other ways, there's a few options. What?
One is being denied services, in my opinion. One is being denied services strictly on the fact that this child speaks Spanish at home, and it cannot be, ruled out that that's the issue.
Okay, so let's talk about this child first. So you're saying that the child was denied eligibility for special education because the child speaks Spanish at home, and therefore, okay, and therefore whoever did the evaluation isn't sure whether this is a language issue or a disability.
They say they can't rule it out.
Well, there's a few things. The parents do have grievance rights, and they can appeal that decision, because we don't want one person being able to have control over that decision without an outsider also being able to review that decision. So that parent, number one, has a few different dispute resolution processes that they can exercise, and I'm happy to chat with you more about what that entails. But if this is kind of a bigger systemic issue that's happening, so it's not just about this one child, it sounds like the district could use some additional training about what resources are available to help make that determination. Because it doesn't sound, we don't want to deny someone services on a guess, right? So there are other options available, and sometimes our special populations team and our ESL team have to team up to kind of work through what is the best way to evaluate the child given their specific needs and their suspected disability. And then the second child, tell me that one again. Okay.
All the benchmarks show very, very slight, almost flatline, just a tiny bit, elevated, but he's not progressive, but doesn't speak English. So therefore, it's like, how are we going to test them?
So the first thing, if you see a child is not progressing, the first question I would have is their ILP really being followed? Are they being given the appropriate services in the amount of time that is required? If those are both a yes, and you suspect that it might be a disability, then I would, there's other ways to do tests that don't require English. Maybe there's certain nonverbal testing, so I'm going to let them chime in after this. Or what OCR says is that you ideally want to be able to evaluate for special education in the child's in the language most likely to yield the most accurate results. So if you can find someone, now that can be really tricky, to find someone who both knows how to do the evaluation and speaks that child's language. But that is considered the gold standard, or sometimes, depending on the test, having a translator in the room. Again, that's not ideal because it can skew the integrity of the results. Jan and Joanne, Katie, do you want to add anything to that?
I do think we have to be careful that we deny an English learner special education services when the professionals that are on the ESL end know that this child needs some special services. And so I think rather than saying I've heard this over the years that many times psychologists feel like they have to rule out English. Well, that doesn't take 6 years, or that doesn't take 3 years. We have to do that as quickly as possible to get the student the services they need.
Thank you. Good question. All right. Well, I think in order for me to give you the best recommendation, I would want to know more details. So can you come find me? And I want to hear more about what exactly is going on with the student, what you suspect their disability, and we'll go from there. That's not me punting this question. That's just me saying we need to talk in more detail. All right. Let's keep going. So as you all know, if a family does opt out, English learners do retain their status as an English learner, and districts must continue to monitor them and assess them to make sure that they are in fact progressing. So we talked about this already, but English learners who do opt out must still have an ILP and annually take the WIDA Access 2.0. What do you do, though, if you have an opt-out family and the child really isn't making progress? There's a number of things you can do. But the first thing that we recommend, and this is actually from federal guidance, so this is what DOE recommends, try to bring the parents back in and have a conversation. They've said no once. Now, you don't want to make it feel coercive, right? Like, you don't want to make it feel, like you're trying to pressure them. But maybe at this point, there's more data to show them, to show how this is negatively impacting their child. And maybe at that point, once they are more aware of how it is having a harmful effect on their child, they might again, or they might rather want their child to have ESL services at that time. But if they still refuse, if the parents still refuse after that meeting, the district must find alternative means of providing the student with the support that they need. So this would involve working with the general education teacher on some classroom interventions. And again, that can be kind of in collaboration with some of the ESL staff. And then once opt-out English learners meet the criteria for exiting the program, they should still be monitored for progress for at least 2 years, is what the federal guidance says. You already know about the scores that are in the state board about exit scores, but there it is just in case. We've talked already about transitional students, so I don't need to get into too much detail. Transitional ELs are considered proficient and must be served in the general education classroom, monitored for 2 years. It's 4 years. Thank you. All right, hold on. We got some disagreement in the room. I'm going to let Jan. My understanding is that
monitored for 2 years.
Right.
The years 3 and 4, you would treat them as any other student, any native English student, but they are included in accountability. There is no protocol required for transition 3 and 4. Thank you. Right.
That is confusing. So let's go back to this bullet point. Here it says they're considered transitional for 4 years, but then on the next slide, they're monitored for 2 years. So years 3 and 4 is for accountability purposes. All right. That is confusing, though. What other questions do you have at this point? Yeah.
If a student exits out of another WIDA state and their score is higher, I know that we recognize the exit score from other states.
Right.
But if they do not exit out and they come to our district, but their score is higher than the 4.2 literacy, I'm sorry, the 4.2 composite, the 4.0 literacy, but it wasn't high enough to exit in the other state, so they're not an exit, but their scores are higher than our exit, do we accept those scores and count them as a transitional one, or do we wait till they take the WIDA the next? Go ahead and C1? No.
The first one. So whatever score they get when they take the WIDA in Tennessee is the score that we would use. What other questions do you have at this point? All right, let's keep moving forward. Are you hanging in okay? Yeah. I'm going to skip through this. All right, everyone, let's come back. We still have a lot of ground to cover. So Jan spoke earlier about having a reclassification process. So if you exit a student and then they are demonstrating that maybe they were perhaps exited too early or, again, need ESL services, every district has to have a process for reclassifying those students as English learners. Here's a little bit more of what that reclassification process should look like or should include. So it should look at things like instructional supports that they've been given within the classroom, RTI, an analysis of their proficiency, and any progress monitoring data that you have on that student. So number 9 is evaluate the effectiveness of the program. This is kind of a broader long-term goal, which means looking at your data from your school, your district's ESL program over the course of a number of years. So there's no specified length of time, it just is a legitimate trial. And you want to ask yourself if the program is producing the results that indicate the students' language barriers are actually being overcome. If your program isn't working and the data supports that, you're going to have to make some changes. So here's just some more guidance from OCR about how you do this assessment. You want to ask yourself if the program's goals are being met without unnecessary segregation. This is pretty in the weeds, and we have more resources at TDOE about how to evaluate the effectiveness of your program if and when it comes time for you to do that. All right, this is a really big topic, and it's a tricky one. So I want to spend some time making sure we talk about communicating with limited English proficient parents. So keep in mind that just because a student is classified as an English learner does not mean that their parent is necessarily going to be an English learner or have any or not be proficient in English. And conversely, you might have a student who is proficient in English or even fluent in English, but their parents are not. So we never want to make assumptions about the family members. But here is OCR's definition. A limited English proficient parent is one whose primary language is something other than English and who have limited English proficiency in one of the 4 domains. So either they're not proficient in speaking English, listening, reading, or writing. Any questions before I keep going with this? Okay. Sometimes it's hard for me to see hands in the audience, so just yell out, Rachel, if you have one. So let's keep going. School districts must develop and implement a process for determining whether parents are limited English proficient and what their language needs are. So a lot of districts will have a questionnaire for parents to fill out to inquire about what their language needs are. The initial inquiry should be translated into language that are common in the school and surrounding communities. For less common languages, districts can use a cover page that kind of outlines in various language what resources are available to that parent so that they can be able to access all the school information in a language that they can understand. Okay, so this is probably one of the most common questions we get. Which documents and resources need to be translated for parents? And I know everyone wants a really clear-cut answer. Unfortunately, there is not a black and white answer. It's kind of a gray area that requires you to balance a number of different factors and considerations. So let's talk through this. OCR says that communication with limited English proficient parents has to be in a language and manner they understand. Manner meaning, what if the parent speaks Mandarin but can't read it, right? Sometimes we have parents who can't read or write, or maybe they have a hearing impairment. We have to make sure that we're communicating to them in not only a language they can understand, but in a method or manner that they can understand. And you have to do so for any information about any service or program that is called to the attention of non-limited English parents. Here are the examples that OCR gives. Information regarding language assistance programs. So if your child needs ESL, you want to make sure that you are communicating that information to their parents in a language that they can understand. Any information about special education and related services. Certainly any documents that are going to be used regarding IEP or 504 plans. Grievance procedures. So if a parent disagrees with the school or the district on a certain matter that you're allowed to file a grievance regarding, make sure that this parent understands how to do so as well. Notices of non-discrimination. Student discipline policies and procedures. Report cards. Requests for parent permission for student participation in district and school activities. This one is a big one. If you are asking a parent to give their written permission, you want to make sure they understand what they're signing, whether it's a field trip or a waiver. I know that goes without saying, but we never want someone to sign something that they can't understand. Information that's communicated during parent-teacher conferences, parent handbooks, information about gifted and talented programs, information about magnet and charter schools, and school and program choice options. So again, this is not an exhaustive list. These are what OCR gives as examples of what they call essential information. Now, there's another test that will help you assess whether a certain document should be translated or not. This guidance comes from the Department of Justice, and this Department of Justice test is not specific to schools, but really it's specific to all government activities. So DOJ says the extent of a recipient's obligation, recipient meaning a recipient of federal funds, so a school district, to provide language assistance to a limited English proficient individual is determined by balancing 4 factors. So here are the 4 questions you're going to want to ask yourself. First, you want to assess the number or proportion of limited English, we'll say parents in this case, parents likely to encounter the program. So if you live in an area where there's a higher percentage of limited English proficient programs, or, people, it's been a long day, that's going to be more likely that you would have to provide those translated documents. The frequency with which limited English proficient parents come into contact with the program. Now this is a big one in the school setting, right? Because we communicate with our parents a lot. So that would certainly weigh in favor of translating certain documents. The nature and importance of the services provided by the program. So again, decisions about a child's educational decisions are considered, of course, to be very important. Now this doesn't mean you have to translate every single document in your district into every single language, but you have to use some good judgment about what documents you think are the most vital for parents to understand. And the last factor to consider is the resources available to the recipient. It's rare to use money or lack of resources to get out of providing translation services. So you're allowed to take it into account under the DOJ test, but it really is not, it's one of many, many factors that has to be considered. So a few more words about communicating with parents. OCR has said that in order to make sure that the information given on the home language survey is as accurate as possible, you ideally want to be able to communicate the home language survey to parents in their home language, in the parent's home language. If that's not possible, perhaps you can use an interpreter to go over the document with the parents. But again, this is the gold standard. Let's talk about interpreters for a minute, because this comes up a lot. OCR says that districts must ensure that interpreters and translators are trained on the role of an interpreter and translator, the ethics of interpreting and translating, and the need to maintain confidentiality. Relying on students, siblings, friends, or untrained school staff to translate or interpret for parents is not ideal, and it may raise Title VI and FERPA concerns. Now, I know this is something you're probably going to want to talk about. I know that this can be very logistically challenging. Does anyone have a question or a comment? None? Oh, I'm sorry, I didn't see you.
So, for example,
Yes.
I'm thinking about when students move here from another country, or from another country, and they're coming into a high school here.
Mm-hmm.
They have a transcript from their country sometimes of the child, not written in English.
Mm-hmm.
If these parents are told, you will need to get this translated, and then bring the document back so that we can get these children in the correct classes.
Mm-hmm.
From my perspective, it seems like that type of a document would be one of the importance, or the nature of it is very important. So placing that responsibility on the parents, I'm a little concerned about that.
Yeah, and I forgot about your question earlier. So let me move to the second bullet point here, because that's a great question. So 2 more bullet points, and then I'll get to that. Number 1 is that you want to ensure that interpreters and translators have knowledge about education-related terminology, right? To put an interpreter into an IEP meeting who doesn't have any understanding of what an IEP is, what disabilities might be being assessed for, if they don't know how to communicate that, that's not going to be considered meaningful communication. And the last bullet point is that it's the district's responsibility to ensure that meaningful communication is provided free of charge. It's not the parent's responsibility to show up to school with an interpreter or to pay translation costs. Now, in your example, did everyone hear this good question? Okay, I'm going to repeat it. So let's say a student arrives at your school and they've moved here from a different country and their report cards and education records from their previous country of origin are not in English. Whose responsibility is it to pay for that translation? You know, that's a good question. On the one hand, I would say that that's needed for the school to make proper decisions about the child's placement. But I would want to double check before I say anything that's being recorded in case I'm wrong. So I want to look into that for you and just confirm, because usually what we're talking about is documents that are produced by the school or the district. So I just want to make sure that I give you the correct answer.
And the follow-up to that are the students that are EL students in high school that could test for credit because they're taking ESL classes, and they could take the Ukrainian test so that they could show that they're proficient in their first language and therefore not have to take the Spanish class or the French class. Again, is that the parent's responsibility to pay for that test to show proficiency? So that's another one.
Well, I want to make sure I understand your question. Did you all catch that? Can you repeat it one more time?
There's a microphone.
Oh, what? Do you want to use the microphone in the middle of the room?
Then we can catch it.
Yeah, because I want to make sure I heard your question. And it's good for us to get some discussion.
Sorry, I don't. So much easier from the safety of the chair. Okay, so the other question is, if a child comes in who is an EL child and they have been told, okay, well, since you're proficient in, let's give you an example, Russian, then you can take a test to show your Russian proficiency, and therefore, since you're receiving ESL services, then you don't have to take Spanish or French, which is offered by the school, obviously. So they still have to take the time, but they'll still have to have the seat time or be in an ESL class, but they don't have to be in an inappropriate class, which would be Spanish, since they are already proficient in their first language. Anyway, to show the proficiency in the first language, they have to take a test. So is that the parent's responsibility to pay for the test? And I'm not talking about a test that the district offers, like a class, like Spanish or French. We would have that test to show proficiency. I'm talking about the students that would be other languages besides those two, or whatever the district would offer.
Foreign language is not a state requirement for graduation.
But it is for the district. And if they want to go to university, I'm just repeating.
Does anyone want to come up to the mic and share their thoughts? Or Jan, Katie, Joanne? So you're saying that
a lot of it depends on how badly do you want that child to count in your grad rate, because you could certainly pay for that. But my understanding has always been that that is a district's superintendent's call. So that needs to be handled at the district level.
So it wouldn't run into OCR at all?
It would if you did it for the Russian student and refused to do it for the Spanish student. Or, I mean, as long as you're equitable and have a written procedure that you follow every time, I think generally OCR is pretty cool with it. It's just when we're not totally equitable with every student.
I can double check, but I don't know off the top of my head. Did you want to share something, sir?
I'm just echoing Jan. I think it runs into what's fair. So if you're doing one-to-one student, if you're allowing a student to take a testing. If you're allowing a student who speak Spanish to take a Spanish test to get credit, and they're not having to pay for that, and you're allowing them into a program based on that, and then you say to an Arabic student, I'm sorry, you've got to pay for your test, then you're actually denying them access into the program that you gave to the Spanish speaker, which would be an OCR violation.
Right. That's correct. So I think to echo what both of you are saying, Jan, you can go ahead and grab the mic, is that as long as you're consistent in the manner, you never want to get into a situation where you're making a policy exception for one student and not another student. Yeah?
Is there any definition of training on the previous slide where it says they must be, the translator, sorry, I'm going back to that they are trained on the role? Is there a definition for that?
I think that varies state by state or according to the program rules. There's not, OCR doesn't dictate what training program someone has to receive, but the point that OCR is trying to make here is that you never want to just use, pull whoever's closest to you to act as a translator, because they are not officially trained, so they maybe don't know the rules of confidentiality or FERPA or things like that. So it's essentially saying that whatever training your state requires to have these credentials, that's who should be used. So being bilingual is not the same as being trained as an interpreter. And again, this is the gold standard. It is, I understand, it's a high bar, and it's hard, especially in parts of the state where there's not as many resources. So if you want to chat after, I can talk to you about some possible solutions if that's something you're struggling with in your district.
Could you come to the microphone so we can capture it?
I think you're making a distinction between IEP meetings, confidentiality. That's one big thing that the translator has to know how to deal with confidentiality. Is that correct? If we're talking about extracurricular activities or special events that you're going to have at the school, then it's not quite that strict. Is that right, or am I wrong about that?
So that's a great question. When we're talking about things that are not so, I guess important is the word. I don't want to say it's not important, but certainly in a situation like an IEP meeting, it's absolutely crucial, right, that the interpreter is providing accurate information. If a parent walks into school and says, hey, what's on the lunch menu today? OCR is not going to ding you. So you just kind of have to use your best judgment. Going back to that list of essential information, I would use that as a guide to help determine when you need to have an interpreter. Now, just last night, as I was preparing some of this, I was reading some OCR investigations about parent open houses, parent-teacher conferences, even school board meetings in areas where there is a high percentage of limited English proficient parents. And OCR did find them to be in violation of Title VI for not allowing those parents to have access to these important conversations in the same manner that English proficient parents could. Does that help at all? I wish there was a simple black and white answer, a quota or some way to make it easier. But it really depends on a variety of factors that we have to take into consideration depending on the circumstances. We always want to strive to be able to do it. If you're ever struggling and you feel like you're hitting a wall, reach out to us and we're happy to try and come up with some solutions to help you. What other questions do you have about this? All right, I'm going to keep moving forward. We are almost done. We're nearing the end here. Oh, you're right there. Go ahead.
I have a home language survey question. If you run across a home language survey that you know is wrong, for example, you've had two siblings that say Spanish, 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 the third one shows up and it says English, English, English. Or you get a brand new school kid in your district and they filled it out English, 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 but the teacher comes to you and said, this kid will only speak in Spanish, won't speak to me in English, won't speak to the other kids in English. we're not even supposed to even do a screener on them unless it says something other than English.
So,
I mean, are we allowed to make changes? Is there a certain policy or procedure? Do we have to call the parents in and say, hey, we need you to think about your answers to these questions? Are we even allowed to question their answers?
great question. I think those are two separate situations in my mind. If you have a family with 3 kids in the same school or the same district, and you know that they live in the same house with the same parents, and 2 of their home language surveys say one thing and the 3rd says another, that to me would signal that there may be an error or an accident that was made, and I would want to have that meeting that we talked about with the parents and just clarify, confirm that they filled out that 3rd one correctly. Now, in the other situation where the parents wrote English, 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 but the child doesn't speak a word of English, it doesn't necessarily mean that what's spoken in the home is a language other than English. And in that situation where it might not be an error, it's definitely, you have to be a little more delicate. I wouldn't move forward with screening that child because that would be making an exception to the policy based on our personal assessments about this child. And my understanding is that when students are also recently arrived, it can take them a little bit longer. Is that correct? They have like a silent period. Do you want to speak to that more? Where they might not just be comfortable speaking right away. So we might want to give it more time and monitor for a little bit longer before we make a decision about whether or not we need to call in the parents for a conversation.
If you're not sure that you are ready to test a student and you may suspect a disability or you may suspect that they're ESL but they're so shy you're not going to get a valid test, you are required to test them in 30 days. So keep that in mind. But it's not much of a violation if you're allowing them to try the ESL class while you're waiting to test them. But you have to have parents' permission. You can't just make that call and say, we're going to put them in ESL, and then after they've tried it for 6 weeks, we'll test them maybe or maybe not. You can't do things against their parents' will without open communication.
Thanks, Jan. All right, we're running low on time, so I want to keep moving forward, and then if you have any questions, you can come up and we can chat about it afterwards. So this is just a reminder that Title VI not only prohibits discrimination against English learners, immigrant students, it also prohibits harassment and bullying of those students on the basis of their national origin, the basis of their immigration status, or their language background. So districts have to have policies in place to prohibit that kind of conduct, and if and when it happens, to correct the behavior and remedy it so that it doesn't happen again. There's a ton of national data showing that in the last few years, bullying and harassment of students who are either immigrants or their parents might be immigrants, they have a different linguistic background. That data has shown that bullying and harassment of those children is on the rise. In Tennessee, we do track this issue, and this was on the decline for many years, but that changed last year. So it's something that I am asking you all to have open eyes when you're in your classroom, when you're in the hallway. If you see any kind of bullying or harassment going on, that needs to be reported to your principal, and that's required both under Title VI, federal law, and as well as state law. So here's the federal definition of harassment. We already went over it. Harassing conduct against students can take a number of forms. What you need to know is that it might be verbal acts, name calling, graphic written statements, conduct that might be physically threatening, harmful, or humiliating to students. Harassment does not have to include an intent to harm. So if you have a student who's making nasty jokes to another student about their immigration status, for example, and you pull that child into the principal's office and the child says, I was just joking, that child needs to have thicker skin. It doesn't matter, whether this person was joking, it's still prohibited. Harassment doesn't have to be directed at a specific target or a specific student. So if there's something nasty scribbled into the wall of the bathrooms against students from Mexico, it's not directed at one specific student, but it could still be considered harassment under the law. It doesn't have to involve repeated incidents. Now this is tricky because I know a lot of you do bullying training in your districts, and a lot of that training says that bullying is a pattern of repeated behavior, right? That's what Alveus teaches and what a lot of these bullying initiatives teach. And that may be true when we're talking about bullying from a behavioral or psychological standpoint, but I'm giving you the legal definition. And the reason I say this is if you have one incident of bullying or harassment, I don't want you to feel like you have to wait for it to happen a second time before you're allowed to take action. So if it happens, don't wait, address it immediately. And under the law, it also doesn't need to involve an imbalance of power. Again, a lot of bullying trainings talk about how when one student is bullying another student, there's an imbalance of power between those two students. Again, that might be true from a behavioral standpoint. Legally, you still have to act even if there is no imbalance of power between those students. All right, so districts must not prohibit national origin minority group students from speaking in their primary language during the school day without an educational justification. So if students are chatting with one another at lunch, at recess, even in the classroom, that's different than providing instruction to the students in English, right? We do have a in Tennessee an English only law that covers instructions. But there's no reason really that I can think of why allowing students to just chat casually in their native language would have an educational justification. Maybe there are some. I can't think of any off the top of my head. Did someone want to add something? No? Okay. Title VI also says that districts must not retaliate, intimidate, threaten, coerce, or in any way penalize a student or a staff member for exercising their rights, their right to file a civil rights complaint. And again, that includes staff who report violations either to the state or to the Department of Education at the federal level. Do remember that civil rights harassment also can trigger the Tennessee bullying law. Here's where the Tennessee bullying law is located in statutory code. And here is the definition of bullying and harassment. This is the state definition, so it's a little bit different. Any act that substantially interferes with a student's educational benefits, opportunities, or performance, and if the act takes place on school grounds, at any school-sponsored activity, on school-provided equipment or transportation, or at any official bus stop, has the effect of doing one of four things: physically harming a student or damaging their property, knowingly placing a student in reasonable fear of physical harm to themselves or their property, causing emotional distress, or creating a hostile educational environment. So if you have a student who's being harassed based on their, let's say, their national origin, do keep in mind that it might trigger your investigation requirements under state law if it also meets this definition here. Students are protected from harassment by other students, by school and district staff, and by third parties. Third parties meaning not students, not staff, people who are on school property for one reason or another. So if you've hired a landscaping company or tutors, any kind of vendor or contractor, they are also not allowed to be harassing your students. I know that goes without saying, but even if they do, it triggers your obligations to correct it. Sometimes, unfortunately, I hear about parents who are on school district property making nasty comments to other students. That is a situation where your obligations to step in and correct it are required. You have to step in. If they're on property harassing your students, whoever it is, you have to make sure that there's an end to it immediately. I know this goes without saying and that no one in this room would ever make these kinds of comments, but of course, comments by staff that are disrespectful or disparaging against our students are of course prohibited. It doesn't matter if you're joking, so that's why it says on here, the use of any kind of racial or ethnic slurs or disrespectful, disparaging, or offensive language relating to a person's national origin or immigration status can lead to a Title VI harassment charge. I was just joking, as I've said, is not an excuse. We need to be sensitive to the fact that a lot of our students and some of our English learners are going through some hard things at home right now, right? Politics aside, this has nothing to do with any of our personal beliefs or our personal politics. It just means that we all have an obligation to make sure that when our students come to school, they're feeling safe and supported. So regardless of your personal feelings on immigration status and everything that's going on at the border right now, I need you to make sure that when you get to school, you are 100% committed to supporting these students. Oops. Here's a little bit about the complaint procedure if a parent or student does want to file a civil rights complaint. It would come to my office or come to the Office for Civil Rights. And then essentially we would open an investigation, ask your school or district for a response, evaluate the evidence. If there's a finding of noncompliance with Title VI, you would enter into a resolution agreement with either the state or the federal government, which is essentially a contract talking about how you're going to remedy the situation and make sure it doesn't happen again. We are running low on time, so I do want to say a few more things. Districts must enroll students regardless of the student's citizenship or their parents' actual or perceived citizenship. It doesn't make a difference. That Supreme Court case that I referenced earlier requires that students have access to a public education regardless of their immigration status. Should a district inquire into the immigration status or citizenship status of a student or parents as a means of establishing residency in the district? No. This is from OCR. Immigration and citizenship status is not relevant to establishing whether a student lives in the district, and it can have a chilling effect, a discouraging effect on student enrollment. We don't want to have policies or procedures in place where students or their families have to fear that enrolling their child in school could result in any kind of negative consequence for themselves and their families. Likewise, schools may not provide any outside agency, including the Immigration and Nationalization Service, with any information from a student's school file that would expose their undocumented status without first obtaining permission from the student's parents. And that's a place where you really want to make sure that you are communicating that information accurately. The one exception is if you have a court-ordered subpoena for that information, in which case I would talk to your board attorney right away. School personnel have no legal obligation to enforce U.S. immigration laws. That's not our role as educators. OCR says that they've recently become aware of districts using certain practices for enrollment that chill or discourage enrollment for immigrant families. So I know I'm breezing through this because I'm almost out of time. Here's what districts may ask for. You can ask for a student's birthday. You can assign that student a student identification number if they don't provide a social security number. You can require a student's immunization records. There are multiple ways to establish a student's residency. Here's what you might not require. Some of these things you can ask for, but if a parent says, no, I'm not providing that for whatever reason, you can't force them to. You still have to enroll them. Can't require a birth certificate or a social security number. Now I know a lot of the policies that I see on websites require these things, so this might mean we need to work together to tweak your language. Remember, asking for these things is one thing, but requiring it for enrollment is another. Full medical records. This is an important one to take note of. You can't require parents to prove residency with a state-issued document. So let's say you had a policy that said parents can only prove residency in the district if they provide a driver's license. Driver's license is a state-issued document. There have to be more flexible ways for a student and a family to prove their residency in the district. If a district chooses to request a student's social security number, it must be clear on all documents in writing that provision of the social security number is voluntary and that not providing it will not bar their child's enrollment. And again, you want to provide that in a language and manner that parents can understand. And we've talked about this a lot, but whatever policies you have in place, you want to make sure you apply them evenly to all your students, right? If you require documentation from one student, you want to require it from all students. We never want to hear about, students with certain last names being targeted and being made to jump through extra hoops than other students. It has to be even-handed. So I'm asking all of you, when you get back home, to take a look at your enrollment processes and procedures and make sure that they comply with Title VI. If you have any questions, please reach out to me, and I'm happy to help you bring your procedures up to snuff. I'm out of time, so I'm just going to really quickly say that charter schools have to follow Title VI as well, and it is the chartering authority's obligation to make sure that they do. So if the LEA has a charter with a charter school, they need to make sure their charter schools are in compliance. I'm going to skip over these roles and responsibilities, but they will be emailed to you, just outlining the different roles of teachers and district staff in all of this. Here are some resources, both federal and state, that might be helpful for you. And here is all our contact information. So if you have legal questions about Title VI, reach out to me. If you have programmatic questions, you can reach out to Jan, Katie, or Joanne. And if you have any questions about WIDA, you can reach out to Megan. My disclaimer is that I'm not allowed to give you any legal advice. But we are out of time, but I'm happy to talk one-on-one with any of you if you have questions, but I don't want to keep people here past time. So I'm going to go ahead and wrap it up. And thank you again for having me.